this is probably my favourite bit of this course. I find all of it fun. In fact, all of these finance courses, this is one of my favourite areas. So one of the things I like about the study of law is the combination of the old and the new often. There's something about finance law that's obsessed with the new, that's obsessed with the now. Often young traders in financial markets have no real memory of the last financial crisis, the last crash. What happened to long-term capital markets in 1998 is before some traders were probably born. What I find interesting about this particular area, liabilities for prospectuses, is that we have a combination of some very old ideas and some very modern. I think understanding where that background is very, very important. Securities law is a combination, I would suggest, of securities regulation, that is, as we discussed in section A of this course, a combination of EU directives at the minute, and the way in which those directives, with their high-level principles, and the Commission's technical regulations are implemented into UK law. So that's been our principal focus. The prospectus rules, the disclosure and transparency rules, the listing rules we look at in section D. But also, when we start talking about liabilities in relation to prospectuses, we're not just thinking about those regulations, we're also thinking about good old-fashioned common law, liability to pay damages in relation to a misrepresentation, whether fraudulent or negligent. We're thinking about mistakes in contract law. We're thinking about all of these areas of law, good old-fashioned, in some cases, 19th century law, and that may seem surprising. Well, it shouldn't. As long ago as 1844, there was an obligation on companies issuing shares to have prospectuses, and for those prospectuses to be registered. And that was a very rudimentary form, in fact, of prospectus regulation. Now, to fast forward to 2013, when I'm recording this, we now have a much more sophisticated regulatory architecture which governs how prospectuses must be prepared, how information must be provided to the public on a continuing basis, and so on and so forth. But in terms of liability for incorrect and misleading statements in prospectuses, misrepresentations, mistakes, and so on and so forth, actually we're still talking about the same root problems that the law on tort and, to a lesser extent, contract law were dealing with in the 19th century. See, there are cases at the very beginning of the 20th century which refer to people fraudulently promoting companies as the old story. Dickens' novels, Martin Chuzzlewit, fascinatingly, has the Anglo-Bengali Disinterested Life Assurance Company, which is run by the fraudster Montague Tigg. And Montague Tigg is running a company on a false prospectus. You might have heard that expression, someone doing something on a false prospectus, where he's drafted up a prospectus which claims that the company has large amounts of capital available to it and lots of investors. And in fact, they're all just other fraudsters and made up numbers. And one of the things that that company has outside its front door is Bellamy, a huge man in a bright red waistcoat under his very expensive jacket, and they look incredibly wealthy. Montague Tigg lives in Pall Mall, and everyone thinks he's incredibly wealthy, and they want to invest in this company because they think it'll make them a fortune. If you fast forward to 2005, that's what everyone was doing in the CDO market, the collateralized debt obligation market, before everything started to unravel and the crash began, almost in slow motion, in August 2007, right the way through to the autumn of 2008, when Lehman Brothers finally collapsed. So we still have this people following these pieces of paper, the statements made in the prospectuses. Those are the things that induce investors to enter into a contract to buy shares, or in the modern context, to buy shares, bonds, warrants, securitized derivatives, whatever it may be. But it's at the old story still. The statements made in the prospectus, this is the marketing material. This is how you sell your product. But there's also a legal context to all of this, that you're required to generate all necessary information in the prospectus. You have to, for example, under the prospectus rules, to pluck one regulation out of thin air, you have to talk about the future prospects of the company. You can't just talk about past information. So there's a requirement there to talk about these kind of important bits of information for the future. And what that means is the people preparing the prospectus are making statements, which, if they're wrong, may cause investors to say, I've suffered loss in reliance on that statement that you made. And so what we have in the modern law are two avenues for redress. The Prospectus Directive, the EU Prospectus Directive, required that there must be a form of legal redress in all the member states to provide compensation in the event that there was an incorrect or misleading statement in a prospectus. And so Section 90 of the Financial Services and Markets Act 2000 has exactly such a provision in it. You can get compensation if there's an incorrect or misleading statement. And that's fun, just that legislative drafting. Does that mean it must be incorrect and misleading? In that way someone might be called William or Bill. You know, they're much the same thing. Or can it be just that it's incorrect, even if it's not misleading? I mean, you and I could be standing outside in a field, and it's pouring with rain, and I say, this is one of the sunniest days I've ever seen. That's an incorrect statement, but it's not going to mislead you because you're soaking wet. So there may be situations in which something could be incorrect, but wouldn't mislead a particular claimant, and vice versa. There are things that might be misleading without actually being incorrect. You might state them ambiguously. So the section as drafted has a huge amount of leeway in it. So, to put it crudely, in your assessments, you're given very practical problems to deal with, and you have to think about that particular legislative drafting. How does it provide compensation here? Now, we hop over the fence to look at what the law of tort does, and of course we have the law on negligent misstatement, we have the law on fraudulent misrepresentation, so that respectively Caparo and Dickman and Derry and Peake, the leading cases there. The common law has been dealing with these issues for a very, very long time. And what's interesting is the recent law, some very little known High Court cases have taken very different approaches to prospectuses, but before the Prospectus Directive. Some cases have said, if you choose to draft your prospectus only for a given narrow group of people, then only those people can possibly be claimants. And anyone who you didn't expect to read this, or you didn't have in your mind when you drafted the prospectus, they can't act as claimants even if they rely on the prospectus. Other cases, like Postfund for example, Mr Justice Lightman have taken the view, no, when you prepare this prospectus, anyone who might reasonably come to rely on that prospectus in the future is entitled to see you as a claimant if there is something about that prospectus which is a negligent misrepresentation. In the wake of the prospectus rules, one of the issues we consider is whether or not that line of case law which says you can't rely on a prospectus if you weren't within the understanding of the person drafting it, if they didn't expect you to be reading it, that can't work anymore because the prospectus rules require you to publish a prospectus, require you to make it available to all possible investors. So there's an argument there now that even leading cases like Caparo and Dickman in the House of Lords, one of the pivotal cases in the House of Lords on tort law in this jurisdiction, might actually not work on its own facts anymore. Maybe the Takeover Code means that that rule is no longer correct. So one of the things we're going to look at in terms of essay writing and thinking about the big picture is what difference is there between the old 19th century common law, which is still good law in this jurisdiction, and the regulatory principles now. One of the key differences is the whole regulatory architecture the Financial Conduct Authority puts into effect every morning. People go in and turn the engine on and switch the lights on. And we'll also look at what's, contrariwise, the effect that regulation has had on our future interpretation of that case law. Must the case law react to the fact that those circumstances have changed? I find this a deeply fascinating area of law. It lets us look at the differences between common law and regulation. It lets us look at the historical context of all these areas of law, and it lets us think about where the law is going in the future. I hope you can get as much enjoyment out of this as I can, because I find it absolutely fascinating.